Ms. Sylvia Lim.
Mr. Speaker, the crux of this bill is to change one of the threshold criteria for disqualification of members of Parliament, the elected President, and members of the Council of Presidential Advisers and the Presidential Council for Minority Rights. In essence, the current law of disqualifying a person once he has received a court fine of at least $2,000 is being amended. The threshold for a disqualifying court fine is proposed to be raised to $10,000. So our view is that the increase to $10,000 moves us in the right direction. The Workers' Party supports this bill. The focus of my speech today will be on the impact of this change on qualifying for parliamentary office, what Minister Chan earlier referred to as the first part of this bill. In its media release on 4th April, the Elections Department highlighted that the disqualification fine amounts had not been revised since Singapore's independence some 57 years ago. Sir, given the forces of inflation and also how fines have been raised by Parliament over the decades, it is undeniable that a fine of $2,000 in 1965 would be a much more significant punishment compared to a $2,000 fine today. Based on a rough calculation of the impact of inflation on prices from 1965 to the present, the figure of $10,000 is within reason. So I should emphasize that, going by this logic, the change brought about by this bill does not represent a lowering of standards for eligibility for Parliament. Instead, it is an attempt to retain the same standards of eligibility that existed when the law was originally enacted. Sir, the task of setting disqualifications from parliamentary office raises questions of national significance. After all, we are dealing with the issue of which Singapore's citizens should be considered unfit for elected public office. This affects the fundamental right of citizens to participate in public life and also the right to continue in office after being duly elected by the people. Some may wonder why we need to be so concerned, since the disqualification based on a court sentence lasts for only 5 years, after which the person can stand for election again. While 5 years is no doubt just one election cycle, 5 years in a person's life is not a short time. Nor should we discount how society could lose from the contributions of an otherwise capable citizen banished to the political wilderness, even if temporarily. Thus, debates concerning the rights of individuals to stand for election or to continue in service merit serious consideration. On the one hand, the current approach of setting the cutoff based on the quantum of punishment by a court is imperfect. If one is targeting fitness for office, the current method makes no distinction about the type of offence involved. A fine and/or a short imprisonment term may be imposed by the courts for many offences with varied moral culpability, ranging from traffic offences to theft. Fines may also be imposed for infractions under some laws which many do not consider criminal in nature. Take, for instance, the recent court case involving a member of an opposition party. Shortly before the general election in 2020, he was fined $5,000 for contempt of court. This placed him over the $2,000 disqualification threshold for standing for election. When he applied to the High Court for clarification on his status, the judge ruled that so long as the court fine was of the required amount, it did not matter what the underlying charge was. The court held that matters considered quasi-criminal, such as contempt of court, would suffice for disqualification. On the other hand, imperfect though it is, the advantage of having a cutoff simply based on the punishment quantum is that it is easy to apply and it is clear to everyone. With the raising of the disqualification fine to $10,000 applied to today's circumstances, there will be a better calibration to target offences of greater seriousness. So while today's amendment is a step in the right direction, I understand, and I stand corrected, that in notable jurisdictions such as Australia and the UK, candidates at a natural election are generally not disqualified if they are merely fined in court, whatever the amount. Instead, disqualification kicks in only when one is sentenced to imprisonment of a certain duration. Sir, given the multitude of regulatory laws in today's modern society, there is always a risk that persons engaged in business or certain industries or professions may be fined for some non-compliance. We may wish to consider in future how relevant the issue of fines is to our disqualification criteria for Parliament. And should we embark on such a further review in the future, careful consideration should be paid to how to balance upholding respect for Parliament as a national institution with having a set of eligibility criteria that is relevant to modern Singapore. To summarize then, the Workers' Party supports the bill to raise the threshold fines for disqualification from Parliament to $10,000. I have also raised a suggestion of a possible future review on the issue of disqualifications based on fines to further examine if it is appropriate to either remove fines altogether or to look at further refinements. Mr. Speaker, we want elections to be contested and to be contested by competent people who are committed and passionate to serve. As an educated electorate, I believe Singaporeans are discerning and will continue to make rational decisions about who should represent them in this august chamber.